SJC-13592, Commonwealth versus Natnael, Zemene.
Orange.
Good morning, Your Honors. May it please the Court. The constitutional prohibition against double jeopardy prohibits the Commonwealth from retrying Mr. Zemene on the charge of carrying a firearm, where the Commonwealth failed to introduce evidence that he lacked a license to carry a firearm during his original trial that occurred post-Bruin, but pre-Guardano. The Commonwealth was put on notice by Bruin that the Second Amendment encompassed an individual's right to carry a firearm in public. Bruin specifically held that the Second and the 14th Amendment protect an individual's right to carry a handgun for self-defense outside the home, and further held that when the Second Amendment text covers an individual's conduct, the Constitution presumptively protects that conduct.
It also Bruin put everyone on notice. In your view, I'm not sure why you focus solely on the idea that it put the Commonwealth on notice. It presumably put everyone on notice to the same thing, of the
That
same
is
thing.
correct.
Okay, so also defense counsel.
Yes, everyone should have been on notice.
Okay, so what we have here is instructional error.
We don't, because the Commonwealth did not, at the time of the trial, the law presumed that the defendant had the right to carry a firearm outside the home.
Oh, so is it your position that the jury were instructed properly in this case?
No, they weren't.
Okay, so it was
they weren't.
instructional error.
It was substantive error, Your Honor, because there were a number of errors that occurred.
All right. For me, it makes a difference to know whether your position is that the jury were instructed correctly on the law or incorrectly on the law.
The jury was instructed incorrectly on the law.
Okay,
but
so
that-
let's just
that
stop there
occurred.
for a moment, if you don't mind. So normally, when an instructional error is unpreserved, we review for substantial risk of a miscarriage of justice. Now, why would that not be the same rule that we would apply here?
We would review this for a substantial risk of miscarriage of justice.
Okay, and
But when-
ordinarily, when that happens, what's the remedy when an instruction is missing an essential element of a crime? What has been the remedy that we have ordered in prior cases?
This is a case, Judge, this is different because this case involves the failure to present evidence to combat a presumptive right to carry. And that's the difference in this case. It wasn't merely a failure to instruct the jury properly. It was a failure to present evidence.
We've had cases like that. We've had cases where the jury were not instructed on an element of the crime and evidence wasn't presented on the element. And do you know what the remedy has been?
Judge, if this is just if there was insufficient evidence, that is a different story. For example, the case involving, Jefferson case, if I can bring out. In Jefferson, the defense had evidence that this was an antique firearm, that it shouldn't have been heard. But the court in that case stated essentially that because the defense was not allowed to present this evidence, it still had a right to be heard. It had a right to be heard on it. And in this case, it falls under the Burke scenario where there was insufficient evidence introduced after everyone was put on notice that the defendant had a right to carry. And that's a different scenario from when it was just a mere instructional error. The evidence was not produced. It could have been produced, such as in Bookman, had the Commonwealth at that point produced evidence of lack of licensure. There would have been sufficient evidence. It would have just been a mere instructional error scenario. But here, the Supreme Court essentially said, this is a right people have. You have the right to carry outside the home. It cannot be.
They haven't directly addressed the issue. They haven't resolved, or at least expressly dealt with the issue we deal with in Guardado, right? they haven't come right out and said what we're supposed to do in this context. We're having to intuit what they want here, right?
Well, I don't think we have to intuit too far, because they did come out and
Well,
directly
they're
state.
saying that states can impose licensing requirements, right?
Certainly, they can. They absolutely can.
And does Bruin say anything about who has the burden of production of a license?
No, but
So
but
it
where-
doesn't say that. So what is the direct connection between Bruin and the proposition that we wrote an opinion in Guardado 1 on?
Well, Guardado said that ever since Bruin, since the decision in Bruin, and that was the triggering point, that was the turning point, the Bruin stated that the Second Amendment protected such conduct, and therefore,
Right, but it didn't say anything about who has the burden of production on a license.
no, but if we look at Winship in the line of cases there, we can't expect a defendant to prove something he has the right to do. It is the burden of the Commonwealth.
I thought Gauss just said that the burden of production was on the defendant, and once he raises the license issue, then the burden of proof under Winship is still with the Commonwealth. Did I have that wrong?
Gauss said that the Second Amendment did not apply, and that's the major difference. And
So
Bruin-
one would have to take Bruin, combine it with Gauss, read Gauss, the rationale for Gauss, and then come to the conclusion that the burden of production that Gauss puts on the defendant is improper.
I would say yes, Your Honor.
And you thought all of that was obvious at the time of the trial.
I stated, it should have been obvious. I'm not stating it was obvious, but it should have been obvious. It was obvious to this court in Bruin, in Guardado, that Bruin changed the law. And because of that change, and it was constitutional law, it wasn't just an interpretation of Massachusetts law, it was a federal holding from the highest court on constitutional law, and it had to be followed. And therefore, making the defendant prove that he had the right to do conduct, to carry on conduct, that the Supreme Court said he presumptively had that right, was improper. And this court...
Right, yeah, then that's not at issue, really. I think the Commonwealth concedes that that was improper, and so the question is only, I thought, whether the Commonwealth has the opportunity to prove for the first time the lack of license.
Yes, and indeed, after reading Bruin, which essentially knocked the foundation off of Gauss, because Gauss was based on the fact that this court interpreted Heller and McDonald not to involve the second, not to indicate that the Second Amendment applied to carrying outside the home. That certainly set up red flags about whether Gauss was still good law in Massachusetts. The Commonwealth could have still...
They're a little different red flags than, Guardado's the guiding light here, right? I mean, we're acting sort of like a federal circuit court, discerning the meaning of the U.S. Supreme Court, right? And so...
I wouldn't say so. I think that the Supreme Court is...
The Supreme Court hasn't directly addressed the question. I mean,
The Supreme Court has... It is a logical trail. The Supreme Court said this is presumptively protected conduct. And therefore, this court... any sort of prosecution has to treat it as presumptively protected conduct, which was not done.
But so that's the inference, right, that you're making there, because the Bruin case was a civil licensing scheme, right?
It was, but it ruled on a constitutional provision in very broad language, and it essentially said this is presumptively protected conduct. Therefore, it can't be ignored. And one way of not ignoring that would be to do what the Commonwealth did in Bookman, which is just to introduce the evidence anyhow.
can you walk me through the timing? There's Bruin, there's Guardado 1, and there's Guardado 2. This case fits in where in that? Because in Guardado 2...
It was before Guardado 1.
So
it was between Bruin and Guardado 1.
Between Bruin and Guardado 1. And so we haven't resolved the meaning of Bruin, at least for Massachusetts courts, until Guardado 2, right?
this case has not officially abrogated Gauss. But
This case falls,
This-
so this case falls after, these are all post-Bruin on appeal, post-Bruin cases, pre-Gordado.
Trial.
Yes, this is what this is. So this court has not abrogated Gauss at the time, but the Supreme Court's holding still must be followed. And that becomes a due process issue in my case, because.
In your view, what could the trial judge here have done? The trial judge was not asked for a different instruction than the one that was given. Guardado 1 had not yet come out. What error did the judge make?
I'm not pitching this on an error
I
of the
understand.
judge.
I understand that, but I have a hard time understanding whose error you're pointing to. You're not raising an ineffective assistance of counsel claim, so you're not arguing that the defense counsel should have challenged this instruction. The instruction is given, became the law of the case, and then the evidence conformed to the law of the case that apparently everyone was satisfied with. I'm not saying it was correct, I'm just saying as the case was tried, that was the law of the case. So who made a mistake?
You cannot convict a defendant on insufficient evidence. and
Sure, that would give you a new trial. That would give you a new trial.
That is the error. I could have raised an ineffective assistance of counsel claim, but instead.
didn't.
I didn't, because it's a substantial risk of justice to convict someone on insufficient evidence.
Right,
And
so
that's-
if you had raised it as an ineffective assistance of counsel, the remedy would have been a new trial. What I'm really trying to zone in on, and I assume it's obvious, is why is the remedy a double jeopardy remedy, as opposed to the remedy that has been used traditionally when we look at all of these similar types of errors, which is that you get a new trial?
Well, because this is, insufficient evidence because the Commonwealth had the opportunity to present it. There was nothing forbidding the Commonwealth from introducing evidence of lack of licensure. And
Wasn't
even if
that the
judge had
case wasn't that the case in Guardado?
Well, it was, in Guardado, the law hadn't changed at that time. We did not believe that the Second Amendment
Guardado
covered.
came after Bruin.
I'm sorry, but the trial of Guardado did not. The trial in Guardado came before Bruin, and that was the law of the land then. By the time Mr. Zemene's trial came, Bruin had issued, and Bruin had said, this is presumptively acceptable conduct. And therefore, the burden was on the Commonwealth to prove that it was not federally.
Have the federal courts dealt with this issue? Because he's going to stand up and cite some of these other federal cases about instructional error, insufficient evidence, but they're not exactly on point, right? Do we have any federal circuit court decisions on this issue? Which is where it's post-Bruin. Maybe we're one of the few states that did this. I don't know if other states had this affirmative defense approach or not. But is there any guidance in the federal courts on this?
I did not find any cases. All the cases cited by the Commonwealth, the law changed after trial. And the difference in Mr. Zemene's case is the law changed before trial. And that's why we are obliged to obey the federal law. And that's why the Commonwealth could certainly, if the Commonwealth had introduced evidence, it would have been a Bookman scenario. It would have been a judicial error in failing to instruct. But because they didn't introduce evidence at that point.
The best thing for you is the statement in Guardado, I can't remember if it's in Guardado 1 or Guardado 2, it says, this was a pre-Bruin case, therefore you get a retrial. Now we're dealing with the gap, which is this is a post-Bruin. Was it so obvious that you had to do this post-Bruin without a Guardado decision? I don't know if anyone's answered that question out there.
I'm not aware of any cases in which this has been resolved. So the
But your
Commonwealth,
basic argument, just so I understand it, is Bruin made it clear that this is something the Commonwealth has to prove, and therefore it's a sufficiency of evidence case, and it's insufficient. That's essentially your argument.
that is my argument.
Yeah, okay.
And in this case, the Commonwealth has conceded that there was insufficient evidence, conceded in its brief. I've addressed the issue, and I would ask that this court order that no retrial occur. Thank you very much.
Thank you, counsel. Attorney Charles.
Good morning. May it please the court. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. With me at council table is Assistant District Attorney Timothy Ferreter. He handled the single justice proceedings in this case and also briefed the Crowder matter, which this court will be hearing next. It is still true, as this court noted in Guardado 2, and just to quote, that at the time of the defendant's trial, this court's precedent clearly had established that licensure was not an essential element.
But that precedent was based on an understanding of the limits of the Second Amendment, which Bruin said were wrong.
So I would agree with that, but I think this court has to take, so number one, I think, as Your Honor already alluded to my sister, Bruin was not a case that was directly addressing the question. The Commonwealth concedes that Bruin did make these general statements about the presumptive protection that the Second Amendment provides to people outside of the home. But it was an administrative case dealing with a licensing regime. It did not directly address any sort of criminal statute. So we're not in a counterman world or in a Johnson v. U.S. world where the United States Supreme Court is making a direct pronouncement on a criminal statute and what needs to be proven or not proven as to a particular element. This was a general statement about a constitutional protection made in the context of a very different sort of case that was not addressing the kind of questions that we're addressing now. I would also generally note, and I know I raised these in Guardado 1 when I was before you, but I think the context here is different. Although none of your honors were sitting on this court back when Gauss and Lodholt and Powell were decided, the way those cases were addressed by this court in a post-Heller-McDonald landscape did not suggest that this court felt that the 278 Section 7 burden of production was invalidated by the Supreme Court's pronouncements in those cases. So for example, this court acknowledged in Guardado 1 that essentially what Heller said was what Bruin said, except in the home. 10H, 269-10H, has always required that the Commonwealth prove as an element of that crime that the defendant either was unlicensed or did not have an FID card in the home. This court did not feel the need, and in fact expressly declined in the Powell case in 2011 to revisit the 278 Section 7 presumption, notwithstanding Heller and McDonald. So the Commonwealth is dealing with 40 years of precedent dating back to Jones that says a license is an exception.
I get the past, but once Guardado, and I'll defer to the author of Guardado, but once Guardado says, post-Bruin, we got to do this. Post-Bruin, you can't rely on the affirmative defense stuff.
I don't dispute the legality of that.
I'm just trying to understand which law is binding on us and in this environment.
The Commonwealth's view is that this court, in terms of the retroactive effect of its ruling, giving the benefit of a new trial to individuals who were tried post-Bruin, is 100% correct.
That's easy. That's the easy part. The hard part is the one we're dealing with right now, which is, okay, this case was tried after Bruin. We have, subsequently in Guardado 1 or 2, say that this affirmative defense doesn't work anymore. How does that work now?
It becomes a question of sufficiency of evidence in double jeopardy, correct?
That's correct,
That's
Your
what
Honor.
it comes down to, is whether or not the remedy is dismissal versus a new trial.
That's entirely correct. And to be clear, the Commonwealth is not suggesting that there's a supremacy clause conflict here, that this court trumps what the United States Supreme Court says. The Commonwealth is merely arguing, and I think the record supports that it was not sufficiently on notice. I believe the language this court used in Guardado 2 was the Commonwealth reasonably could have known. And what I'm arguing to you now is that the Commonwealth, until this court decided Guardado 1, could not reasonably have known that this 40 years of precedent was invalidated based on the general statement that was made in the context of a decision by the United States Supreme Court
That's
that
the
had nothing to
standard?
do.
I just want to make sure I understand. So it's the sufficiency of, because we have insufficient evidence, right? We all agree there's insufficient evidence.
Judged by the new post-Guardado standard, yes.
Right, so there's insufficient evidence, there's the Bruin decision, and is this sufficiency of notice that Bruin, where do we get that? Do we get that from Guardado? I'm just trying to understand, if I'm writing a decision that makes your point, what do I cite for the idea? Okay, Bruin's been decided, subsequently this court says in Guardado, the affirmative defense doesn't work, but we weren't sufficiently on notice, therefore we get a second try. I'm just trying to, what do we cite?
I would agree that there's not a case to directly point you to, but I think it's a confluence of cases. It is the cases that the Commonwealth cited in Guardado 2 and in its brief, in this case, from the federal circuits, acknowledging that those cases dealt with the change of the law, the post-dated trial, talking about this idea of getting a second bite versus a first bite at the apple.
Those,
And it's
again, those are easy. It's the
and cases like
predated.
Runyon, for example, that the Commonwealth cites in its case, 456 Mass at 234, because I believe, as Justice Wolahojian was questioning, what could we have expected trial courts to do? Bruin was not a direct pronouncement that provided clear guidance about the effect on Massachusetts criminal prosecutions and the burden of proof and the burden of production. Our trial courts had clear guidance, 40 years of clear guidance, that persisted post-Heller and McDonald from this court.
Does Guardado cut back on that, though? When Guardado says Bruin, I don't know if Guardado says this, makes clear that this affirmative defense approach doesn't work, how do we take that into account? And also, Guardado's easy because it's a pre-Bruin case, so it says you get a new trial. It fits in with your federal cases. Are there any cases where we have this, the Supreme Court's issued a general principle, it hasn't addressed this very specific question, and then Massachusetts clarifies that, but
So the Commonwealth
in Guardado, it's retroactive. And I don't mean to cut you off, I'm just trying to articulate what I can't understand.
The Commonwealth's position is that setting aside the obvious wrinkle that these federal cases dealt with post-trial changes in the law, the underlying rationale of those cases and why it makes sense to grant a new trial but not preclude that new trial on the basis of double jeopardy is that the Commonwealth is not being given this second bite at the apple. It's not that it was clear to the government or, frankly, to defense attorneys or defendants or judges of the trial courts in this Commonwealth that this had to be done. So to the Commonwealth's knowledge, essentially every single trial that occurred between Bruin and Guardado 1 occurred in the trial courts of the Commonwealth without defendants requesting this instruction, without trial judges recognizing that this was an element that the Commonwealth now needed to prove, and without the prosecutor, the government, understanding that it needed to introduce evidence it unquestionably had, because no defendants who provide proof of licensure are being
As a
prosecuted.
practical matter, we understand, that's obvious. But again, the Supreme Court's double jeopardy jurisprudence is pretty, it can be pretty rigid. And I'm just trying to make sure, are there cases where are there cases that we can look at, Supreme Court cases where they say, okay, because we hadn't directly addressed the specific point, even though we'd sort of given general guidance, there's not double jeopardy in an insufficient evidence case? Are there things?
So the Commonwealth is not aware of that case. I think, again, we can look to cases that are not directly on point but somewhat helpful. For example, the Beal case. There, this court did apply double jeopardy principles against the Commonwealth, and that was in part because the defense attorney at trial raised this issue. They squarely raised the idea that an assault and battery conviction standing alone was insufficient to establish the predicate for an armed career criminal. And the law was not clear, but the defendant had put the Commonwealth on notice, and the Commonwealth proceeded at its peril, and therefore this court had no qualms with applying double jeopardy. And I can't say that that was an incorrect application of the law. But here, no party to the prosecution, to the case, put anyone on notice. And again, just to address a question that you directly asked before, Justice Kafker, while the Commonwealth was not able to find any federal cases, New York does treat unlawful possession prosecutions in the same way that the government, or that the Commonwealth does in Massachusetts. They essentially view a license as an exception to the statute that takes you out of the criminal sphere. And in 2023, they decided a couple of cases, Cabrera, 41 New York 3rd, 35, and David, 41 New York 3rd, 90, where the defendants raised a variety of similar constitutional claims post-Bruin. Now, ultimately, those courts determined that those claims were waived because in New York, if you don't raise it at the trial court, you don't get to raise it on appeal. But in the Cabrera case, the court did sort of directly address at page 49 and 50 this idea of like, what did Bruin directly address? And they said, quote, Bruin did not address the rest of New York's licensing scheme or the interplay between the invalidation of New York's proper cause requirement and state statutes criminalizing unlicensed possession of a firearm, end quote. So the one other jurisdiction that's sort of similar.
Can I ask?
Yes.
So are certiorari been sought on those cases? And are there, from what I understand, one of the briefs says certiorari is it still pending in Guardado?
No.
So certiorari has been denied in Guardado.
Okay.
That was pending at the time of briefing and has since been resolved.
Okay.
And I apologize, I should have looked it up. I'm not aware of the certiorari status of those New York.
Well, you said they were waived claims.
They were, the court did view them as waived. I don't know enough about the New York jurisprudence to understand whether that was an erroneous conclusion by the Court of Appeals, but they certainly concluded that under their jurisprudence, they were waived claims and therefore they weren't going to address them.
I understand your point that no one directly raised this as a matter of notice, but it could be helpful to talk a little bit about notice in the more substantive sense. And I think that it is a source of confusion that the court in Bruin talks about the burden, talks about a burden in a way of that this is presumptively lawful conduct, and so therefore the burden on some level will be on the Commonwealth to prove a crime has occurred, versus a Winship issue like we have here where we have a burden of production and then the burden of proof was actually on the Commonwealth. So can you talk about a burden that comes out of Bruin versus a burden at issue here? Because I think isn't that the heart of the notice question?
Again, not to fall back on a point I've already made, but I think in assessing, separate and apart from the fact that Bruin didn't directly address any of the stuff that we're talking about now, looking back to how...
Well, hold on. It absolutely did, right?
In the macro sense, it did, because obviously this court in Guardado 1 interpreted those general pronouncements and applied them to our case law and determined that prior precedent, Jones and Gauss and these other cases were no longer valid. But I only mean in the sense that it was not, it's not akin to these other sort of federal cases from the United States Supreme Court that have prompted an immediate reaction in lower courts like Rahafe or Barrage or Johnson.
Okay, well, let me give you a different hypothetical. So, and this is intended to be a friendly question, because I think it's a difficult question to think about the burden of proof and a burden of production. So so Guardado said this is, you can't have a state statute that presumes that no one can have a handgun, and you have to get special permission to get one because of the Second Amendment. So if you had a state criminal statute that was sort of very much akin to an analog of the New York regime that said it is a crime to be out and about without a license for any... You understand my point?
Yes.
That, even though Bruin was not itself a criminal case, wouldn't you understand Bruin to have essentially abrogated that criminal statute?
Yes, I think then we would be in a situation akin to what this court dealt with in Cruz post-Counterman, where you're getting a clear direction from the United States Supreme Court and everyone understands what they're saying vis-a-vis our criminal statute.
So speaking doctrinally and trying to relate it to Winship and a presumption, a burden of production, can you articulate why this is different?
I mean, at a base level, it's different because the Commonwealth always retains the burden of proof as to licensure. There hasn't been any shifting of a burden. Essentially, it's just a preliminary step that what the Commonwealth would characterize as a very minimal preliminary step reasonable preliminary step that our courts were asking defendants to bring because, I mean, not to state the obvious again, but I think generally if someone produces a valid license at the time they're stopped or a firearm is found or any time prior to a complaint or an indictment being returned, they're not being charged. No one's proceeding on a prosecution against someone who's lawfully licensed to carry a firearm. So this was the imposition of a very low-level initial burden on defendants, granted at a time where perhaps we had a less centralized system that I think Justice Gaziano pointed out in Guardado 1 and 2 during oral argument is perhaps not the same today as it was back then. But at the end of the day, the Commonwealth is still, once being put on notice of this, of the fact that the defendant is claiming they do have a license, they're still being required to prove it. So the statute.
And so you don't view that placing the burden of production on defendants as analogous to the violative of Bruin criminal statute that I was hypothesizing?
I don't view it as apples to apples. But again, I think it's a little bit removed from the core question of, which is essentially a notice question, right? Because if we're talking about a sort of, I mean, I don't rely on both my sister here and my sister in the other case are quick to distinguish the specific facts of the Jefferson case. The Commonwealth cited that case, and I believe this court cited that case in Jefferson or in Guardado too, more for the idea of these fairness principles where none of the parties involved are aware that this is an obligation, and where there hasn't been a direct pronouncement from a higher court that is sufficiently clear so that the government can reasonably understand that it has that obligation. I mean, it's a tougher case
my problem is you just don't I get it in a certain sense, but we don't have any authority for this. It was sort of clear, but not really clear, right?
Well, again, you piece it together from different things, right? We have Vasquez and Runyon essentially saying that the Supreme Judicial Court is the highest court of the Commonwealth, and lower courts are obligated to follow its pronouncements. We have 40 years of precedent from this court.
But we're on the federal side here, so we're more like. That's why I was interested in your federal circuit court analysis. But again, all of those involve post. We're
A post-trial change.
I understand her argument is simple. Bruin was decided. You said in Guardado that Bruin's clear, and got rid of this. Therefore, and then it becomes an insufficient case. Your argument is Bruin wasn't that clear, and therefore we weren't on notice. It seems like.
So I think that's correct in a sense. To give a hypothetical, if this was a situation like Counterman, where the government had proceeded post-Counterman and not sought to make the requisite showing, I would say there would be a stronger argument that double jeopardy would apply because the decision of the United States Supreme Court was fairly clear and direct. I think what we're asking you to do is to sort of apply those federal circuit cases that we've cited and the spirit of those cases, which say, yeah, okay, yes, let's acknowledge that the change in the law there was post-trial, but it was still a new rule. And here, the government didn't understand the new rule because it wasn't clearly stated in the United States Supreme Court decision that is the basis for it.
So
it was sort of a tangential flow.
I'm just trying to make sure I can articulate your argument. So Bruin has set out a general principle, but the SJC, until Guardado, has not made it clear what its interpretation of that decision is. Therefore, you're really only bound by SJC law on this and not the U.S. Supreme Court's, because the U.S. Supreme Court hasn't definitively ruled.
That is the argument that the Commonwealth gave to you, yes. And if we were in a land where...
Okay, so now I understand that argument. Now, can I ask you about waiver? Does waiver get you anything that no one's raised this? I'm just trying to understand how that works.
Given how this court has interpreted its waiver jurisprudence, I'm not sure what... I would have made the argument if I felt it would have availed the Commonwealth.
If you were in New York, maybe.
If I was in New York, perhaps. But as the Commonwealth understands this court's waiver jurisprudence, it doesn't avail the Commonwealth of much.
But when we've interpreted the U.S. Supreme Court, you can waive... I don't know if you can waive double jeopardy issues. That's the problem, right? Do we go to a substantial risk in double jeopardy? I thought we don't.
I'm not sure we even get, I mean, I'm not even sure it's a matter of which standard applies. If it's a straight double jeopardy question, if it's a straight insufficiency question, and the Commonwealth and this court finds that the Commonwealth was on notice, then I think we lose.
Right, if Bruin had held the burden of production on licensing cannot be on the defendant, then I think you'd be in a different world.
I would not argue with Your Honor that we would lose in that scenario. And I'm sure there's a variety of other hypotheticals where the court could have said something that was somewhat clearer, that wasn't that direct, but that was still clear enough to put the Commonwealth on notice. Here, again, at the risk of being a broken record, that wasn't what Bruin was about. I don't dispute that these general pronouncements were made, but this is not a case like Rahafe or Johnson where the United States Supreme Court is saying, attention lower courts, when you try this particular type of criminal case, the burden is on the government to prove X. That was nowhere near anything said in Bruin. And so to now hold that against the government and say, all of these defendants get a get out of jail free card and you can't retry them, when we clearly had the evidence at our disposal, and had we had any inkling that it was required, even from defense counsel, which again, neither this defendant nor Mr. Crowder.
A little difficult to say he had no inkling given what we said in Guardado, but I get your point. You may not have been sufficient.
Pre-Guardado, no one
had
not had that guidance.
Right, but Guardado is an interpretation of Bruin. But I understand your point is you didn't have sufficient notice given that Bruin hadn't specifically addressed the question.
Correct. Again,
And we're going to see you in a little bit.
That's correct. So
All right.
I'll rest on my brief as to this and ask that you remand for a new trial and allow the Commonwealth a first opportunity to prove what it did not know it previously had to prove. That is
Almost misstated that, huh?
Thank you, Your Honors.